Good morning and good afternoon, ladies and gentlemen. Thanks for attending this webinar, and thanks for waiting. We were just waiting for more attendees to join the call. The hot topic of today is how to avoid or minimize labor risks when hiring employees in China, and the recent reform of the individual income tax that came into force on January 1st, 2019, with specific reference of two main changes that will be effective from next year. For foreign companies, handling human resources in China may be challenging for many reasons, such as cultural differences and the presence of many different laws and regulations at city or even at district level that regulates in a different way several aspects of the PRC labor law, with reference, for example, to the maternity leave regulation, sick leave, minimum wage, social insurance rates, and many others. In the first part of this webinar, Dario Marotta, associate at Oxford, will introduce the main elements of payroll composition in China and considerations on the changes that the individual income tax reform will bring from next year, how this will affect companies, and how they shall get ready for that. In the second part, Matthew Warr, legal consultant of Zhonglun law firm, will talk about one of the main concerns for foreign enterprises in China, that is how to avoid or how to minimize the labor risks when commencing or terminating an employment relationship. There will be a Q&A session at the end of this presentation. Please feel free to raise your questions. You can submit them through the message box on the right side of your screen, or feel free to reach us after the presentation. My name is Francesca Scortichini. I'm an associate director at Oxford. As a way of introduction, please allow me to spend a few words on our company, who we are and what we do. Oxford is a company specialized in providing services and advisory for inbound investment to Asia. We serve more than 1,000 multinational companies in different industries with a global team of 250 people speaking multiple languages and provide a comprehensive package of services, including market entry advisory, corporate, accounting, tax, human resource and payroll, as well as tailor-made solutions for different needs. We have 5 offices in China, including Shanghai, Changshu, Beijing, Guangzhou, and Shenzhen, and also in Hong Kong, Singapore, Jersey, London, and Milan. Now, let's get started, and I give the word to my colleague, Dario Marotta.
Thank you very much, Francesca. And good afternoon and good morning to everybody. To understand the imminent changes in individual income tax that will affect enterprises as well as foreign employees in mainland China, it is important to take a step back and analyze the key role that HR function can play in the company's everyday operation and why such function shall not be underestimated as part of the strategic and financial planning of a company. The role of the HR department sees its development into 3 major stages, starting from the onboarding process, where candidates are interviewed, background check is carried out, labor contract and company handbook are signed off, and social contributions are linked under the company's account. When it comes to daily operations instead, HR plays a key role in keeping a clear record of attendance, payroll calculation, disciplinary actions, contracts, company handbook, and arrangements for trainings and performance reviews, till the termination part, whether it's a mutual termination, resignation, or a unilateral termination. All documents need to be correctly filed and social contributions timely interrupted to avoid unnecessary company costs. When it comes to payroll calculation, new investors might struggle to understand the difference between gross salary and company cost. Therefore, a quick review of a payroll in PRC might help us understand this key point, especially needed when computing budgets and employee benefits. The payroll starts from the salary package, usually the gross salary included in the contract, plus any basic allowance, subject then to bonuses, commissions, and overtime, as well as deductions referring to leaves and social insurance contributions from the employee side. These three together make up for what is called a gross salary. On top of the gross salary, however, there are social contributions from the employer's side, which are at the employer's pure cost. The sum of gross salary and employer's contributions provides the company cost, which is therefore always higher than the gross salary that might be agreed upon in the labor contract, and that needs to be considered when planning new hirings and salary reviews for budget purposes. Now that the concept of company cost is clear, we can move forward to assess the current IIT system, individual income tax system, and see how it will change starting from next year. For company distributing monthly salary to employees, IIT is prepaid on a monthly basis by the employer on the cumulative taxable income intended as the salary generated on the basic contract agreement, plus or minus any attendance fluctuations, from which we also deduct social contributions, a standard deduction of 5,000 RMB, and a number of deductible allowances, which we'll approach with further detail in the next part of this presentation. Once all deductions have taken place, the exact taxable income is assessed and linked to the correct tax bracket. There are currently 7 tax brackets for taxable income, covering the cumulative individual income generated over the fiscal year, with a progressive tax rate going from 3% to 45%, which might vary during the year, depending on the accumulated income at the point in the fiscal year when the payroll is computed. To each tax bracket, a dedicated deduction is assigned, named Quick Deduction, which further reduces the IIT payable in the month or in the year. IIT is usually withheld by employers on a monthly basis, based on the cumulative income for the individual, and then reconciled on a yearly basis. IIT reconciliation usually takes place in the first half of the following year and can be done by taxpayers, their employers, or an authorized third party. Individuals domiciliated in China are subject to IIT reconciliation, as well as foreign nationals who spend more than 183 days in mainland China, unless the yearly income is less than 120,000 RMB and the tax in arrear is less than 400 RMB. The reconciliation is meant to give everybody the possibility to comply with tax filings, as well as to have access to tax makeups and refunds, especially important for those individuals with more than one source of income or those who have switched jobs during the fiscal year. Being each payroll created on the cumulative income generated within the company, changing jobs will erase historical data, and having 2 sources of income at the same time requires a yearly reconciliation to make sure that the overall income sits in the correct tax bracket and the appropriate IIT amount is levied. Now that we have gained a general understanding of how IIT works, let's analyze the 2 main changes that will affect payroll creation as well as employee cost budgeting. From January 1st, 2022, annual bonuses will become part of comprehensive income, while special deductions previously available to foreign employees will be cancelled. Let's have a look at those changes one by one to understand the contents, how they will affect employers and employees, and how to possibly get ready for these new challenges. Most of us will be familiar with annual bonuses, especially those distributed by the year-end or by Chinese New Year as a 13th salary or a performance bonus. This type of compensation is currently considered as an independent source of income and taxed separately from the salary received during the same month. Starting from January next year, bonuses will be included in the comprehensive income when calculating IIT, thus increasing the taxable income for the fiscal year. This means that rather than treating the bonus as a separate item, when looking for the correct tax brackets for taxable income, we shall sum monthly salaries and bonus, treating the two as a single part. It is important to mention that this change might not necessarily result in higher IIT for taxpayers. As a matter of fact, let's take, for example, an employee receiving 180,000 RMB of yearly salary and 150,000 RMB of annual bonus. In the before reform section, we can see how the calculation for IIT is isolated from the one referring to salary, while in the after reform period, bonus and salary end up in the same basket. In this very specific case, the total IIT paid before the reform, given by the sum of bonus IIT and salary IIT, is over 9,000 RMB more than the IIT calculated on the comprehensive income after the reform. Once again, deductions play a key role in such computations, as they affect the tax brackets where the comprehensive income sits, which results might be opposite for smaller bonuses that, if taken alone, might generate little to no IIT. The second major change in IIT computation that is going to take place in January 2022 refers to the deductible items currently being assigned to foreigners. Expats have now access to a number of special deductions to reduce IIT payable that will be abolished starting from next year. These allowances are for housing, meals and laundry expenses, relocation expenses, flights for home visiting, language trainings, and children education expenses. All these special deductions previously granted on a reasonable amount are now being aligned with those assigned to Chinese nationals with a precise limit per month or year. Namely, they are children education, continuing education, medical treatment of serious illness, mortgage interest, elderly care, and housing rent, where the last one varies depending on the size of the city of employment. The reductions in terms of deductible allowances is significant, especially for foreigners living in first-tier cities with children enroll in international or private schools, thus raising labor costs related to foreign staff, which imply further considerations. If we take, for example, a foreign employee working in Guangzhou with an yearly income of 800,000 RMB, we can notice that in case the deductible items available to their end are housing allowance and children tuition fees for a total of 160,000 RMB, when shifting to deductible allowances assigned to Chinese nationals, housing and children education deductions are therefore limited to a total of 42,000 RMB, which leads to an increase in IIT burden of around 24%. It is worth mentioning that in case the labor cost available in the contract provides for a gross salary, this will result in a lower net salary for the employee, while if the contract salary is a net one, the company cost will increase at the employer's cost. How can companies get ready for these changes? It is essential to stay up to date on most recent policies and understand their contents, which most of the time come in Chinese only and cover technical aspects which stakeholders might not be familiar with. Thus, the importance to have a specialized HR team in place or seek for professional advice from certified third parties. Once the contents of the policies are clear, the analysis process starts by creating a before and after reform projection, which will eventually bring to a plan for salary packages and relevant negotiations with employees, while keeping an eye on any tax benefit available to foreign talents. Employers and employees have several options to get ready for these changes. First of all, it will be important to assess how much time foreign employees are going to spend in China in the fiscal year in order to budget an adequate IIT plan and further consider possible contract and salary allocations among separate jurisdictions, depending on the actual working location and employer. When discussing expat packages with current employees and potential candidates, it is important to evaluate in advance the impact of the IIT reform and possibly plan the salary position as well as the actual company costs beforehand in order to negotiate all benefits involved and avoid hidden costs. Despite the increasing IIT burden might sound like a repellent to foreign talents, specific regions and sectors in China still offer favorable IIT treatment to certified foreign talents through a wide range of tax relief programs. Worth mentioning among the many is the Greater Bay Area Foreign Talent IIT program, limiting IIT payable to only 15% of taxable income of eligible candidates, which together with other enterprise income tax benefits make the Greater Bay Area one of the most attractive locations for foreigners investors in China. It is worth mentioning that there are still 6 months till the end of the year, so we can't rule out further updates to these policies and extensions to the current one or the introduction of brand new benefits. What we can suggest is to be proactive and start planning for the future starting from today, keeping in mind that the fiscal treatment for Chinese and foreign nationals would be aligned in the near future, and potentially companies would mainly benefit from other industry-related subsidies or local programs in line with national policies for economic development. Thank you very much. I will now hand over the microphone to Matt.
Thanks Dario and Francesca, and thanks for the opportunity to collaborate with Hawksford on this webinar. My name is Matthew Waugh, and I'm a legal consultant at Zhonglin Law Firm Guangzhou office. And my presentation will cover how to avoid labor risks when hiring and firing employees in China. So these are my contact details and the QR code for my personal WeChat. So if you want to contact me after the presentation, feel free to do so. But rest assured, we will send you a link to the recorded webinar after our presentation, so you'll be able to find my contact details again if you didn't get a chance to write them down or scan the QR code now. So I have a lot of content to cover today, so I'm going to get straight into the presentation. So this is the agenda, which is divided into 2 parts. Part 1 will cover the commencement of the employment relationship, and part 2 will cover termination of the employment relationship. So some of you listening may actually know quite a bit about Chinese labor laws. Maybe you're a HR manager at your company, or you've had a company in China for a long time and have experience hiring and firing staff. But I'm going to take the approach, at least for the next few minutes, to avoid, as they say, the trap of knowledge and assume everyone knows absolutely nothing about Chinese labor laws. Therefore, I'm firstly going to introduce two important labor laws in China and one very important rule that these laws introduced. So firstly, the two most important labor laws in China are the labor law and the labor contract law. The labor contract law was a very significant piece of legislation introduced back in 2008 and effectively made labor contracts mandatory in China for full-time employees. There are quite a few other laws that govern labor relationships in China, such as those that govern such things as holidays and leave, protection of female employees, minimum wages, and work safety. I won't be covering these issues in the presentation. This presentation will cover mainly issues related to the commencement of the employment relationship and the termination of the employment relationship. And the above two laws are by and large the main two overarching labor-related laws in China related to the establishment and termination of labor employment relationships. So quite a bit of content in my presentation will come from these laws, particularly the labor contract law. Now, the first question that I want to address is how to legally hire employees in China. Well, firstly, the labor contract law requires that a labor contract must be signed with employees within 1 month of starting employment. Otherwise, the employer may have to pay the employees double their salary for each month up to 11 months without a contract. A caveat to this rule, however, is that this rule only applies to Chinese citizens. It does not apply to foreign nationals. And this is because for a court to recognize an employment relationship between a foreign national and his or her employer, and thus for that foreign national to be protected by China's labor laws, such foreign national must obtain a valid work permit to be considered as legally working. And in order to be granted a valid work permit, the employer needs to submit a signed labor contract, among other documents, to the Foreign Experts Bureau first. So if a foreign national does not have a valid work permit, a labor arbitration commission or a court would not even accept the foreign national's case. So it's impossible for a foreign national to have the right to double salary if the employer does not sign a contract with the foreign national, as this would effectively mean that they don't have a work permit, because the employment contract was needed to obtain the work permit in the first place. This third point here about if the employer fails to conclude written labor contracts with employees within 1 year from starting employment, they should be deemed to have entered into an open-ended contract. Again, this only applies to Chinese nationals. And what entering into an open-ended contract basically means is that the employees become lifetime employees, and it is essentially much harder to terminate them. This underlines the importance of signing contracts with all your full-time employees, but most importantly, your local Chinese full-time staff. So as a concluding thought for this slide, I want to say that there is often a misconception amongst new foreign companies in China that China is not a contract or legalist culture like many Western countries are, and that therefore contracts don't matter here. Once upon a time, in fact, before the labor contract law came into force in 2008, there may have been some element of truth to this, at least in terms of complying with the law. But recently, and I can say that based on my experience working in the legal services industry in China for the past 4 to 5 years, contracts, especially labor contracts, absolutely do matter. And the courts will come down hard on employers, especially foreign employers, who do not execute labor contracts with their employees. So here's a case study related to commencing the employment relationship in a legal way. However, firstly, I just want to note that while China's legal system is quite unique compared with legal systems of other countries around the world, its legal system is largely a civil law system. reflecting the influence of continental European legal systems, especially German civil law. It does not have a common law system, as is the case in countries such as the US and Australia. And this basically means that precedents of past cases in China are not used by courts directly to make decisions. You will only see legislation referenced in an official court judgment on a case, unlike in the United States, where courts actually reference cases in making judgments. The important point here is that the outcome and judgment of the case in this slide, of the cases in this slide, of the case in this slide and the cases that will follow and other may be different if the case, if the same case was heard in a different city in China. Although if the facts are clear cut, it would likely be a similar decision no matter where the case is heard in China. So do keep this in mind when I'm presenting these case studies. Okay, so the background of this case is that the employment candidate accepted an employment offer from an investment company in Shanghai. And after receiving the offer, the employment candidate submitted a resignation letter to his current employer. However, before reporting to work at his new employer, the employment candidate received a notice from his new employer's HR stating that his start date would be postponed for an unlimited period as his offer had been rejected by the group company. The employment candidate then sued the investment company for revoking the employment offer. So, okay, so what was the court's judgment and opinion in this case? Well, the company argued firstly that it revoked the offer because the employment candidate had lied on his resume. However, the court found that the company name on the employment candidate's resume was an affiliate of his prior employer, and therefore his job history was authentic. The court found that the investment company was at fault for causing the employment candidate's unemployment and hence was liable for damages. And the court ordered damages of 10,000 RMB based on various factors, including the employment candidate's monthly salary, the salary amount offered by the company, and the degree of fault of the company. So what are the key takeaway points from this case study? Well, employers will be held liable for revoking an employment offer to an employment candidate without a justifiable and lawful reason if the employment offer has induced the employment candidate to resign from their current position. So before revoking an employment offer, employers should be sure that there is a justifiable and lawful reason. Courts will apply the principle of fairness in their own discretion when evaluating the revocation of an employment offer. So in this particular case, if the court had actually found that the employee did intentionally lie on his resume and his previous work experience was completely fabricated and he did not have the qualifications for the position he was hired for, then the court would likely rule in favor of the employer in the event that the employer withdrew the offer based on this reason. So for this slide, I've included these rules on foreigners and work permits in China, as I'm sure that quite a few of you listening are foreigners yourselves or are Chinese and work for a foreign invested enterprise. And because these issues are very common in China, yet I'm constantly surprised at how few people living in China are aware of these rules. And it has to do with rules relating to foreigners switching employers and or the location of employment and how that relates to their work permit. So the first point up here, work permit is needed by foreigners to legally work in China. I think this is pretty obvious to most of you listening, but what's less obvious is if a foreigner changes employers within the original area designated by the relevant authorities. So let's say Shenzhen or Guangzhou, but stays in a job of the same nature, let's say an English teacher moving from one school to another school. In this situation, it would only require an update of the work permit, not an entirely new application. However, if a foreigner moves to another city, let's say from Shenzhen to Shanghai, or even Shenzhen to Guangzhou, and stays in a job of the same nature, let's say again as an English teacher at a school, then technically, according to the law, a new work permit application is required. In practice, however, an update is often permitted, but it really depends on the place and the circumstances. One thing that the authorities are stricter on is when a foreigner changes employers within the original area or outside the original area and takes a job of a different nature. That is, they change their industry. So for example, a foreigner changes their job from teaching English at a school to being the general manager of an engineering firm. One reason for the new application requirement in this circumstance is because the new job may require additional qualifications. So I've included another case study here related to the legal location of employment of foreigners in China, which happened a few years ago. So this case involves a foreign national who signed an employment contract with a company in Shanghai to work as a tennis coach in Beijing under the daily management of the Shanghai company's Beijing branch. The Shanghai company sponsored the employee's work permit and residence permit in Shanghai, and then the employer later resigned when the Beijing branch refused to pay his salary. The employee filed a labor arbitration claim in Beijing against the Shanghai hiring company. I would usually ask the audience to have a guess at how the arbitration commission ruled based on what I've just told you, but this is a webinar, so I'll just get straight to the answer in the next slide. So the foreign employee's work permit clearly stated that the employee's approved work location was Shanghai, and working in Beijing was therefore considered as illegally working. The foreign employee was not entitled to labor protection under Chinese law, and therefore the Labor Arbitration Commission rejected the employee's claim for severance pay. So what are the key takeaways for this case? Well, firstly, I just want to say it's actually quite common in China for employers, particularly foreign employers, to hire all employees through its headquarters in one city, but then send the employees to work in another city. But it's really important that when employers hire foreign nationals, both employers and employees should be very careful about following immigration requirements and permitted place of work. All work and residence permits should be obtained in the city where the foreign employee will actually work to avoid potential liabilities. Otherwise, the employer could be fined between 10,000 and 100,000 RMB. All illegal gains from illegal employment could be confiscated, and the foreign national could also be deported. The denial of labor protection to the employee may have worked in the employer's favor in this case, but both the employer and the foreign national employee could face potential legal liabilities as a result of such an employment arrangement. Business trips to other cities are generally fine, and even extended business trips, for example, managing an office in another city for a few weeks. But if a foreign employee's labor contract states that such employee is meant to work in one city, but for the most part of the time they are working in another city, a Chinese court will probably deem this as illegally working and will not award payment of unpaid salary or severance pay if the foreign employee is illegally terminated. Okay, so now that concludes the first part of my presentation. Now to the second part, termination of the employment relationship, which is probably the more interesting part of the presentation, as termination is probably the most common labor-related issue that we deal with here at Zhonglun Law Firm. Okay, so firstly, just some basics about terminating employment relationships. At-will terminations, not permitted. There is often a misconception amongst foreign nationals in China who have just started a business in China that employees can be terminated at will, like is often the case in the US. This is certainly not the case in China. Terminating an employee legally in China without having to pay severance or reinstate the employee is actually very difficult for employers, both foreign and Chinese. There are limited grounds, in fact 6 grounds, for terminating an employee's contract before that contract has expired without being legally required to pay severance pay. Unless an employee satisfies one of the 6 grounds for termination without notice and severance pay according to Chinese law, then it's almost impossible to terminate the employee without being legally required to pay some form of financial compensation. So I'll cover these 6 grounds in the next slide, but just on this second point, the burden of proof lies with the employer in Chinese labor disputes. It is critically important to communicate everything clearly to your employees and witness and record everything. This includes getting employees to confirm in writing by signing that they are aware of and agree to the company's internal rules and regulations, which should be contained in what is known as an employee handbook. If a labor dispute arises with an employee and it ends up in arbitration or court, and the employer cannot present sufficient evidence to justify a legal termination, then the arbitration commission or court is much more likely to side with the employee. Chinese labor law is very employee-centric. Okay, so as I mentioned in the previous slide, there are 6 grounds according to which an employer can terminate an employee without notice and severance pay. So these 6 grounds are listed here in this slide. I'm not going to read out all the grounds, but I would like to focus on 2 of them. Specifically number 2, if the employee materially breaches the employer's rules and regulations, and number 5, if the employee uses deception or coercion to induce the conclusion or amendment of the labor contract. So ground 2 is perhaps the most important ground because it relates to the employee handbook, which is an important company document where the employer's rules and regulations, in which the employer's rules and regulations are contained. So there are 2 issues here. 1, whether the rules are valid, and 2, whether the breach was material. Materiality, which basically means seriousness, may ultimately need to be decided in each case by a labor arbitration or litigation process. To give an example, in one case, an employee was dismissed for making excessive phone calls at work in violation of the company's rules. And the company had a rule in its handbook that personal phone calls were limited to 1 hour per week, but the employee was proven to have made more than 20 hours of such phone calls during the 2-week period. The court upheld the dismissal and supported the employer in this case. There are also plenty of cases related to absenteeism, for example, consistently turning up late to work or missing work for a few days. It is largely up to the court's discretion whether 1 week of missed work time, for example, is sufficient for immediate dismissal without pay, but to increase the chances that a labor arbitration commission or court will find in favor of the employer, it's important that the employer give warnings, both verbally and in writing, to an employee leading up to the dismissal. In most cases, the arbitration commission or court would probably not consider 1 missed day, for example, as material or serious enough. Also, as I mentioned previously, as China is a civil law and not a common law country, the judgment of an arbitration commission or court in one area in China may be different to another regarding the materiality of the employer's rules for the exact same case. But by and large, what the arbitration commission or court would be looking for here will be whether the rules are valid. For example, did the employee agree to the rules and regulations when starting employment by signing a statement stating that he or she had read such rules? And has the employer produced sufficient evidence of this? And was the offense material or serious enough? This can often come down to the arbitration commission's or court's discretion. Regarding ground number 5, when an employer uses deception or coercion to induce the conclusion or amendment of a labor contract, a common offense here is when employees are fired for resume fraud, thereby making the labor contract invalid. I'll cover this ground in a case study in the slides to follow, but first I want to talk about a case study related to ground 2 above, when an employee materially breaches the employer's rules and regulations. So as for the background to this case, a number of complaints were made about quality issues of the company's products, which was the responsibility of the workshop quality manager. The employer sought to transfer the employee and reduce her salary and annual leave, but an agreement could not be reached. The employee then made a request for 3 months sick leave, which was supported by a hospital certificate. The company paid the employee 3 months sick leave. However, if the employee traveled to Malaysia for 1 week during the sick leave, violating the company's rules and regulations. Therefore, the company terminated the employee for not agreeing to the new work arrangement and the misconduct of traveling when she was apparently sick. And the employee then challenged the termination and made a claim for severance pay. So in terms of the court's judgment and opinion, the court held that it was lawful in this case for the company to terminate the employee based on the company's rules and regulations, and the court therefore dismissed the employee's claim for severance compensation. In terms of the key takeaway points for this case, it's really important, as I just mentioned, to have a well-crafted employee handbook, including specific examples of misconduct, such as misusing sick leave. The handbook should be signed by all employees when starting work, or for employees already employed, introduced or amended to the legally required employee consultation procedure. This will increase the likelihood of the termination being considered lawful. So I've got another case study here. So this one relates to ground 5 that I discussed before in the previous slide, when an employer uses deception or coercion to induce the conclusion or amendment of the labor contract. So as mentioned, a common offense here is when employees are fired for resume fraud, which this case study demonstrates, thereby making the labor contract invalid. As for the background for this case, the employee joined a Shanghai-based company. The employee listed on the company's employment application and on his CV prior work experience with 2 companies supposedly operating in the same industry as the hiring company. However, the company discovered that the 2 companies did not exist. The company therefore terminated the labor contract on the grounds that the contract was invalid. And this was because the company had intended to hire the employee with appropriate industry-related work experience, but was tricked into hiring the employee without that experience based on the employee's fraudulent work experience claims. The company also demanded that the employee return all salary and bonuses paid. So you might recall from the previous case study 1 earlier in this presentation, that the company in that case study revoked the job offer because the employment candidate had lied on his resume. But in that case study, the court found that the company on the employment candidate's resume was an affiliate of his prior employer, and therefore his job history was authentic, and thus ordered the company to pay employment candidate damages. However, in this case, the court ruled in favor of the company on the contract the contract invalidation claim. The court held that the labor contract wasn't valid because the false information provided by the employee had induced the company to sign a labor contract contrary to the company's true intent. The court, however, rejected the company's claim for reimbursement of salary and bonuses, and the court held that the employee should be paid for services rendered to the company, even though those services were rendered under an invalid contract. So in this case, the resume fraud was proven by the company to be real, and thus the court found in favor of the company. So in terms of key takeaways for this, the employee should conduct basic due diligence when hiring employees to avoid future disputes. For executive level roles particularly, employees should conduct thorough background checks to verify key employment information provided by the candidate before making an official offer. And employers may terminate employees who provide false information during the hiring process if the misleading information was key to the hiring decision. However, they likely cannot claim salary and other compensation already paid. Okay, so I've now covered the 6 situations under which an employer can terminate an employee without being legally obligated to pay an employee severance pay and give notice. Now I'm going to cover briefly situations under which the employer can terminate employees but they must give notice and pay severance pay. So regarding point number 1 in the slides, when an employee suffers from an illness or non-work related injury and the prescribed time period for medical treatment has expired, the employee should be allowed to first attempt to go back to work in his or her original position or another position arranged by the employer. Also, the medical treatment period is usually between 3 to 24 months, depending on the length of employment, and reimbursement for some of all of the costs of medical care may also be available. Regarding point 2 in the slides, termination for employee incompetency, there should be some factual basis for this determination, such as deficiencies in the measured performance in view of announced job expectations, as or reassign the employee. The performance assessment standards should be made known to all employees in advance, which should be confirmed by employees in writing and also included in the appendix of the employee handbook. The assessment results should also be recorded in writing and filed in the employee's personal records. Regarding point 3 in the slides, some examples that may be considered as a change in objective circumstances include loss of licenses, relocations, reorganizations, mergers, acquisitions, or even a loss of a big client. And regarding point 4, the employer is undergoing a mass layoff. The employer must satisfy certain criteria to be eligible for this grant and certain prerequisites to use this grant, but I'm not going to go into details on this in this particular presentation for lack of time. So there are certain employees that are protected from termination by an employer, which are listed in this slide. Although I'm not going to go into detail on this presentation for lack of time. And also there are certain employees that are prioritized for retention in mass layoffs, which are also listed in this slide, although I'm not going to go into detail on this slide for this presentation. Okay, so termination by employees. This is a pretty important slide. So basically, employees can terminate their labor contract for any reason upon giving the employer 30 days prior written notice. However, employees can usually terminate their labor contract immediately, that is without the 30-day requirement, by giving the employer written notice because the employer caused the occurrence of any of the following 5 reasons in the slide. I say usually here because most courts have ruled that the written notice should be given, but without the 30-day requirement, while some have ruled that the 30-day prior written notice requirement is required for resignation due to the reasons in the slide. So the legislation is quite ambiguous on this, which is why there is some differences between the judgments of different courts. I won't read out all the reasons here, but one of the most common ones is when the employer fails to pay the social insurance premium for the employee. I will demonstrate this by way of a case study in a minute, but it's important to note that if the employer does not pay their employees the social insurance premium and the employee is aware of this, they can essentially resign in writing for this reason, and the employer would be legally obliged to not only make up the social insurance premium, but to also pay the employee severance pay. So this slide includes some other reasons why an employee can usually terminate his or her labor contract immediately, that is without the 30-day requirement, by giving the employee written notice. Again, I say usually here because most courts have ruled that the written notice should be given, but without the 30-day requirement, while some have ruled that the 30-day requirement, 30-day prior written notice is a requirement for the resignation due to the reasons in the slide. Importantly, though, an employee can terminate his or her labor contract immediately without giving any prior notice to the employer if the employer uses violence, threats, or unlawful restriction of personal freedom to force the employee to work, or if the employer forces or instructs the employee to perform dangerous tasks which would endanger his or her personal safety. Again, severance pay is required when the employee resigns to any of the above circumstances. Okay, so this is a final case study that I've included here that demonstrates an employee resigning immediately, that is without the 30-day requirement, by giving the employer written notice because the employer underpaid the social insurance premium for the employee and other employees in the company. So as for the background of this case, the employee received a monthly salary of 3,000 RMB. The employee subsequently discovered a clause in her contract which confirms that the company used the minimum calculation base rather than her individual salary for her social insurance contributions and therefore underpaid the social insurance for her. The company used the minimum amounts of 1,350 RMB and the salary base for her pension, unemployment, working injury and maternity insurance contributions, and the minimum amount of 800 RMB as the salary base for her medical insurance contribution. The employee further discovered that the company underpaid social insurance for its other employees by using the minimum base amount for the social insurance calculations, and therefore the company sued. So therefore the employee sued the company for severance pay. As for the, so for this case, for both the first instance and appellate court, both the first instance and appellate court upheld the employee's claim, and the courts held that the social insurance is a mandatory obligation imposed upon employers and it cannot be waived either by the employee. It cannot be either waived by the employee or avoided or reduced by agreement between the parties. So key takeaway points for this case study: courts are taking a stricter approach on social insurance underpayment, and it is likely that an employee who brings a claim for severance after resigning as a result of underpayment of social insurance will be successful. Employees should therefore undertake an audit to ensure they are compliant with the mandatory social insurance contribution laws, and if not, start planning how to rectify the situation. So for this slide, there are some other termination circumstances requiring severance pay, but I think the most interesting point here is point 2, the fixed term contract expires. So many foreigners, in fact, don't know that they are entitled to severance pay when their contract simply expires and the employer refuses to renew it. And point 1 above is also important, particularly when termination is proposed by the employer. Many foreigners get tricked into resigning voluntarily in writing despite the employer having proposed the termination in the first place, meaning that the employee gives up their right to severance pay. I won't cover the other points. Compensation payment calculation for termination with cause. There are 2 main scenarios for calculation. So the scenario 1 is where the employee's salary is less than 3 times the local average, and the calculation for this is pretty straightforward. It is the employee's average monthly salary times the years of service. And then also scenario 2 is where the employee's salary is higher than 3 times the local average, and the calculation for this is 3 times the average local of the city in which the employee works times the years of service. The reason for scenario 2 is to basically limit the amount of severance very high salary earners can claim, particularly if such high salary earners have been working for the company for a long time. And this in some way reduces the financial burden a bit on the company. So any period not less than 6 months but less than 1 year is counted as 1 year, and any period of less than 6 months is counted as half a year. It's also important to note that the years of severance service for scenario 2 in the previous slide is capped at 12 years. Again, this is to reduce the financial burden on the company a bit by limiting the amount of severance very high salary earners can claim, particularly if such high salary earners have been working for the company for more than 12 years. An average monthly salary basically means the employee's average monthly salary for the 12 months prior to the termination of his or her labor contract, and the calculation of the average salary also includes bonuses, allowances, and subsidies. Okay, so this is a very important slide and outlines what would happen if an employer terminates an employee for any reason not permitted by law. That is the reasons that are included in the slide shown previously, some of which I've talked about. So if the employer terminates an employee without cause, the employer must continue employing or reinstate the employee if the employee requests this. However, often if the employee does not request this or continued employment has become impossible due to a breakdown in employment relations, the employer may be liable to pay severance pay at twice the normal rate, that is 2 months per year of service, unless the company can reach an agreement with the employee on a lower amount. Okay, so here are some initial steps that employers should take when they want to terminate an employee for one or more of the permissible reasons outlined in this presentation. I won't read them all out, but step 5, provide the employee with an agreement on termination of the labor contract to sign, particularly if severance payment is required. This is a particularly important point, so I'll talk very briefly about this. So basically, the agreement should include details such as severance payment amounts, payment instead of notice, if applicable, return of company property by the employee, confidentiality obligations of the employee post-termination, and a waiver of future claims against the employer. An experienced HR manager should have some experience in preparing such an agreement, but if this option isn't available, usually it's wise to use a law firm to prepare such an agreement in the event of a termination. So here are some procedures that need to be followed, particularly for foreign employees. The first point, the employer being required to issue the employee with a release letter when the contract is terminated or ends. This applies to both Chinese and foreign employees and must at least contain the term of the labor contract the date the contract was terminated, the position of the employee, and the time working for the employer. However, for foreign employees, it is also a legal requirement to cancel their work permit upon termination of the contract through the online system of the Foreign Experts Bureau, and then provide the foreign employee the original of the cancellation certificate issued by the Foreign Experts Bureau. This is quite important because employers not providing foreigners with their release documents is extremely common in China, particularly in schools, who use it as leverage over their employees who wish to change employers. So the previous slide is important because if release documents are not provided and the employee suffers, this slide is important because if release documents are not provided and the employee suffers a loss, for example, loss of a new job opportunity, the employee may be able to make a potentially large damage claims to a labour arbitration commission or court. And for foreign employees, as mentioned, the employer is required to report this to the Foreign Experts Bureau and cancel the foreign employee's work permit via the Foreign Experts Bureau's online system. And also report it to the Entry and Exit Administration Bureau, which is basically the authority in charge of visas and residence permits. Okay, so just some final tips before I wrap up. Termination. When you're terminating your employees, try to terminate by mutual agreement if possible. Do not miss any time limits during the dispute resolution process. The burden of proof in most cases lies with the employer. So it's therefore very important to make detailed records and request employees to sign everything before, during, and after their employment period. Without sufficient evidence, the employer will likely lose in arbitration or court. Have a well-crafted employee handbook and make sure that all employees sign this when they start their employment with the company. And finally, and most importantly, plan for employee terminations the day that you hire. So that concludes my presentation. I think now we will move into the questions and answers part.
Yes, thank you. Thank you. Thank you very much to the speakers, Dario and Matthew. We still have a few minutes for answering questions from the attendees. I think from your presentation is pretty clear how vast and complex HR matters can be in China. And the feeling we have sometimes as a professional advisor is that underestimating or not being familiar with those matters can bring risks and costs to the employers. So let's go to the questions. We received a couple of questions during the submission of the registration forms. I'm going to read them. The first question is rules regarding the outsourcing of work by Hong Kong. I have to say this topic is out of the scope of this presentation today because it is more related to the Hong Kong labor law, but both Oxford and John Loon have offices in Hong Kong, so we will raise this query to our Hong Kong office and maybe get back to you with by email later. The second question is, I'm interested in companies hiring related to expat here in China. I think this matter has been covered by before. However, if there are still doubts or more information you might be interested, please, there are our emails, contacts, so feel free to reach us right, and we will reply to you. Another question we received is, do you think the cancellation of expatriate IIT exemption is determined or still lobbying with the government? We know this termination of tax-free allowance for expat is a very hot topic now, and there is a big effort from Chamber of Commerce institutions to try to understand how to minimize the impact of this change. I would like to address this question to you, Dario. Maybe if you can add a few more words about that.
Sure. It's definitely a hot topic, and there is lobbying going on right now. So at the current stage, I would say that we are in a wait and see kind of a situation, meaning that we still have half year ahead, and we cannot exclude that anything is going to happen. It's important to see that, to look at the bigger picture, meaning that right now we are in a period of transition, which started in 2018 with the actual IIT reform. During the presentation, we mentioned the standard deduction, which is now 5,000 RMB for both foreigners and Chinese nationals. This is a change that was applied in late 2018. So the direction is to align tax treatment for both foreigners and Chinese. However, we cannot exclude any change in the current situation, an extension to the current benefit, the introduction of new ones. We can't rule out any possibility right now. So for now, we can just wait and see, I would say.
Thank you, Dario. Yes, we all know that here in China, when there are changes, there can be introduced very suddenly. So we still expect that some further updates or information may be released later on in the year. We have received another question, and this is for Matthew, related to legal. It's in addition to the 2 times compensation payable for unlawful termination, are there cases where employees have successfuli claimed other damages? And if so, for what and how much? Can you tell a little bit about your experience or what about the law is saying about that?
Hi, Francesca. Could you read that question out again?
Sure. In addition to the 2 times compensation payable for unlawful termination, are there cases where employees have successfully claimed other damages? And if so, for what and how much?
Yeah, that's a very good question, actually. I might get back to that person via email, but I mean, there are cases basically. I mean, you can claim for work for example, if you suffered an illness or a work-related injury, you can claim. There are cases where employees have claims can claim the medical costs to being reimbursed by the company. So that's just one example, but yeah, I mean, I might think about some more examples for other damages in addition to a legal termination, and get back to that person who asked that question.
Thank you, Matthew, for your answer. Okay, there are no more questions that we received on our platform, but I say this once again, if you have still doubts or more cases or information, please feel free to contact us later. The time is now run out, so I will conclude this presentation. Thank you very much, everyone, for attending. We can send you the presentation for those who are asking, and also we want to inform you that on our website you can find lots of guides and articles or more information covering not only HR related matters, but other compliance and hot topics in China. Okay, thank you very much for your attention, and have a nice evening and enjoy the rest of your day. Thank you.